because I believe there were some ERRBAC issues in connection with this contract. That information I've just passed on to you came from our view of the minutes and related bills. Perhaps board members who were there have a recollection as well.
And Mr. Bassett did have his own counsel as well.
Yeah.
Is that an accurate statement of your involvement, your firm's involvement?
I wasn't involved. I wasn't part of the firm back then, so I'm not sure of the timing. But I know our firm was involved. I know that Mr. Bassett had counsel, and I know that there was a retirement attorney that was involved as well.
I'll make a statement here more than anything else, and I've only attended 2 meetings, this being my third. There seems to be a propensity to have counsel review counsel work, and it's something that I think we have to pay close attention to, because we certainly need to be concerned about our legal bills. Those legal bills compound when we have one counsel reviewing another counsel's work. Either we have to trust counsel to produce the work we want, or not trust them and don't hire them. But when we trust them to do the work that we're asking to do, then having another attorney review that attorney's work seems to be duplicative at a minimum. So I make that as a general statement to some of the other things I've seen. It seems to be somewhat relevant in this particular case. And in either case, the result was not one that was in the favor of this board. Any other particular comments to what's being discussed by the board members?
I'd like to hear about if we had a situation where the 2 law firms, one representing Mr. Bassett and you people, as to whether is there a time frame that you can get together and talk about maybe a compensation thing without this going to arbitration?
Oh, we could engage in that immediately with permission of the board. Now, whether it would be fruitful, we don't know. But I think given the costs to both parties of the arbitration itself, it would seem to be in both parties' interest to at least talk and see if there's some common ground. Admittedly, it might involve ultimately a recommended payment by the board to Mr. Bassett to terminate all matters with respect to the board, but you have the risk, obviously, of paying him for some period of time during which the arbitration is pending, and you could lose the arbitration. It appears to be, we think, well-founded, but as you can see with the litigation in Superior Court, it's not our judgment that ultimately will be at issue. It will be that of the arbitrators, and they may decide differently, in which case there could be a larger monetary award. So there's risks to both sides, and it would seem to me that both sides would or should be interested in settling this matter short of arbitration. But we would have to, if you would like us to do it, we would have to be authorized to do that with obviously no ability to make a commitment, solely to make a recommendation.
Now, if that's the situation, and say that the 2 sides can't meet, then it would then go to arbitration anyway. Is that right?
Correct. That's correct.
Yeah, so I think it's a step that's worth taking, and as far as I'm concerned, it's a step worth taking to see whether anything can be resolved between the parties.
The only concern I have relative to that context is this. You begin a dialogue. Those dialogues can last however long. In the meantime, the arbitration, as I understand it, is on our end of the decision when we proceed forward with contacting AAA, identifying, if you know the process, identifying the backgrounds of a series of arbitrators. We review those. The opposing counsel reviews those, decides which arbitrators we want to select. There can be a contestation process relative to that. All that, if we don't begin that process in some fashion, quite frankly, it just extends the time period by which we could ultimately pay Mr. Bassett. In other words, you get into a 2-month negotiation about a possible outcome. We haven't started the arbitration process. Then we start the arbitration process at the end of that. It's 2 months more time relative to what we may compensate Mr. Bassett. So,
but aren't you paying double on what you just said you'd be paying?
You are.
Yeah.
Yeah, you have,
I mean,
that's why it's a complicated question.
That's what I was trying to figure here, that if we did it on one step first, which is trying to get the settlement, and if it doesn't work, then go to arbitration. You're not paying double
Well, I
way you said it.
just did I just have done all these steps. The initial step would be to file a complaint for declaratory judgment with the AAA. But keep in mind, it would be advantageous to discuss with counsel for the other side whether they'd like to proceed in some alternative fashion, including just picking one arbitrator. That cuts costs immediately. You could pick a well-respected retired judge, and using the arbitration rules, you can start to shorten costs. But this all takes the ability to discuss that with the other side. They theoretically should be interested in lower costs as well, provided they have a voice on who the arbitrator is, which they would. So I think it might be worth, you could proceed on two steps. We could negotiate first, and then if that's unavailing on at least the procedure, take the steps toward filing. But we do meet again. I think the board meets again in about 2 weeks. So it would be relatively rapid in terms of a report.
Thoughts? Other thoughts? Let me add one piece to this. I think we certainly, however we proceed, it seems like we'll need counsel to represent us. Given the fact that your firm, with no disrespect to your firm, has represented us on other matters with Mr. Bassett as the chair and as the executive director, I personally could not recommend you as the counsel that was dealing with this particular matter. I think it provides at least an appearance of a conflict, maybe not at a professional level, but certainly the appearance that your relationship with Mr. Bassett relative to his role as chairman and executive director makes it complicated. Some would argue it makes it easier because of the relationship. I just think it doesn't create the correct appearance to have your firm handle any negotiation relative to the matter of Mr. Bassett's termination. I don't know what the other board members' thoughts are relative to that.
Mr. Chairman, would it be possible to avoid legal counsel and have a committee, a subcommittee within the retirement board handle this?
I mean, ultimately, we're going to want a review of what the product looks like.
Right.
Certainly, I'd entertain that. I'm not sure what the other members' thoughts are relative to that.
If I could, I would say that the current law firm is a firm that represented the board, and there were a couple of things that were done where they were not representing Mr. Bassett at all. They were just representing the other members of the board. He was only as chairman, but he was not being represented by them.
No, I agree that he was not individually being represented to them. My comments were to the fact that they've represented the board while Mr. Bassett was both the first member and the executive director. And I believe, personally, that it does not reflect well on the board to have that same firm involve themselves relevant to the termination of Mr. Bassett. I believe that it's better to bring in an alternative counsel, that this board could evaluate their qualifications so that there's not any question about. We attended a meeting. I happen to be in attendance and not the chair. There was a discussion about the termination. There was a process involved, that went on discussing the rights of the board and the like at the last meeting, all being advised by the council. And then in turn, we're going to have a lawsuit associated with that, or at least a discussion around arbitration. And I think it makes sense relative to how to move this board forward to have an independent law firm that did not have an involvement relative to that discussion handle any negotiations we have if it's not handled by the board. And in the end, again, I'm one vote as well, but that would be my strong recommendation.
If we were to go that route, to select another law firm, how would we go about doing that? Would we maybe at our next meeting try to get different attorneys in here, or what's your thought on that?
I think we'd do exactly that. We'd assign 1 or 2 members to Mr. Martineau's comment, whether that's us handling the negotiation or an alternative, assign 1 or 2 members to the process of identifying counsels with a specific expertise, get a copy of a letter of engagement relative to their the information, their backgrounds and their particular expertise, and a cost per hour of the work that's expected. The board would evaluate those resumes, the law firm version of a resume, and decide how best to proceed, and would do so in public session so we would know exactly what their backgrounds were, their expertise were, and the cost per hour would be. And then make that decision at the next meeting.
Okay, I think that would be a good choice. It'd give us all an option to give us an option on our different attorneys, and so we can choose one that I think would be in our best interest.
I'd also, although we're not in the form of a motion yet, and I certainly don't want to dismiss Mr. Martineau's comment, do we want to have further discussion of what